I have heard people call me unfair. I've been called stubborn. I've been called intimidating. Over the years, I've learned that losing parties often search for someone else to blame. But there was one morning I will never forget. A heavy-set woman named Karen Walker stood in my courtroom, pointed her finger directly at me, and shouted across the room, "I pay your salary." The courtroom froze. Even the bailiff looked surprised. I looked directly back at her. I didn't raise my voice. I didn't lose my temper. Because after decades on the bench, I've learned something very simple. The loudest person in the courtroom is rarely the one holding the strongest case. And believe me, by the time Karen understood what my next reply actually meant, every ounce of confidence she walked in with had disappeared. Before we go any further, make sure you have subscribed to this channel for more powerful courtroom stories like this one. And if you haven't subscribed yet, do it now. Also, comment below and tell us where you are watching this video from. Now let me take you back to where this case truly began. The plaintiff was a man named Daniel Brooks, 44 years old, owner of a small roofing company, professional quiet, the type of man who answered questions directly and never added unnecessary drama. Across from him sat Karen Walker, 48 years old, expensive designer jacket, luxury handbag resting beside her chair, a thick stack of printed internet articles she repeatedly referred to as legal research. Years on the bench teach you something important. Owning printed laws is not the same as understanding them. Karen appeared convinced otherwise. The lawsuit involved a roofing contract. Daniel claimed Karen hired his company to replace the roof on her home after storm damage. The work was completed. County inspections passed. Final invoices were sent. Karen refused to pay the remaining balance, $42,000. Interesting, very interesting. Karen insisted the roof was defective, not because it leaked, not because it failed inspection, because she simply believed it had been installed incorrectly. That distinction immediately caught my attention. I asked Daniel to explain the project. He calmly presented the signed contract, material invoices, inspection certificates, photographs documenting every stage of construction. Everything appeared organized, very organized. Karen interrupted before he finished his second sentence. He's misleading the court. Interesting. Very interesting. I looked toward her. You'll have an opportunity to speak. He's twisting everything. You'll have an opportunity to speak. Karen sighed dramatically, folded her arms, then leaned back in her chair. Years on the bench teach you that people often mistake interruptions for confidence. They aren't. Usually their insecurity wearing a louder voice, Daniel continued. He explained that Karen personally approved additional upgrades midway through the project, premium shingles, extra ventilation, reinforced flashing. Everything had been documented with signed change orders. Interesting, very interesting. Then I turned toward Karen. What specifically was defective? She immediately opened one of her folders, pulled out several printed articles, and began reading technical roofing terminology. Interesting, very interesting. The words sounded impressive, very impressive, until I asked one simple question. Did any licensed roofing inspector conclude the installation was defective? Silence, doppelt still silence. Karen looked down at her papers, then back at me. Finally, she answered, no. Interesting, very interesting. Did any engineer issue a report? No. Did the county inspector fail the roof? No. The courtroom became very quiet. Because now we had a problem. Karen claimed catastrophic workmanship, yet every qualified inspection supported Daniel's work. Years on the bench teach you that opinions matter. Expert opinions usually matter more. Then Karen suddenly stood up without permission. She pointed directly at me and loudly announced, "You judges forget who works for who." Interesting. Very interesting. The spectators exchanged nervous looks. Daniel remained silent. Honestly, he looked almost embarrassed for her. I calmly asked Karen to sit down. Instead, she took one step closer, raised her voice even higher, and shouted the sentence people would discuss for years afterward. "I pay your salary." The courtroom froze. Complete silence. Nobody moved. Nobody spoke. Even Karen seemed satisfied with herself, as though she had just won the argument. Years on the bench teach you that moments like this reveal far more than legal evidence ever can. Because people under pressure often expose exactly how they see the world. Karen believed authority could be intimidated. She was about to discover she had chosen the wrong courtroom. I looked directly at her, smiled slightly, and gave one calm reply, a reply so simple yet so devastating that Karen's expression changed before I even finished the sentence. And honestly, that wasn't even the biggest mistake she made that morning. The moment Karen Walker shouted, "I pay your salary," the courtroom became so quiet that I could hear papers shifting on counsel's table. Years on the bench teach you that silence often says more than shouting ever could. The courtroom remained still. Daniel Brooks sat quietly. The spectators watched carefully. Karen stood confidently with her arms crossed, apparently expecting me to react emotionally. She chose the wrong judge. I looked directly at her and calmly replied, "Mrs. Walker, if that's true, then Mr. Brooks pays my salary too." The courtroom remained silent. I continued. "So does every taxpayer sitting in this room." Another pause. "And that's exactly why I work for none of you individually." Interesting, very interesting. Karen's confident smile disappeared almost instantly because she had expected an argument. She received a lesson instead. Years on the bench teach you something important. Judges do not serve the loudest voice. They serve the law. That distinction matters a lot. I asked Karen to return to her seat. This time, she did. Without another word. Interesting, very interesting. The change in her body language caught my attention immediately. Only moments earlier, she looked completely certain. Now she appeared irritated. And irritation often causes mistakes, very expensive mistakes. I turned my attention back to Daniel. He quietly handed me another folder, neatly organized, every document labeled. Interesting. Very interesting. Inside were signed change orders, one after another. Premium materials, additional labor, ventilation upgrades. Everything carried Karen's signature. I reviewed the first document, then another, then another. The signatures appeared consistent. Dates matched. Material costs matched. Nothing immediately seemed unusual. I looked, "Did you sign these?" A pause. Then, "Yes." Interesting, very interesting. "So you approve these upgrades?" "Yes, but only because I trusted him." Interesting answer. Very interesting. Because trust does not invalidate a written agreement, years on the bench teach you that contracts exist precisely because memories change. Documents usually don't. Then Karen reached into another folder. Interesting, very interesting. She proudly removed a thick binder, nearly 300 printed pages, internet articles, blog posts, forum discussions, dye roofing advice, everything. She placed the binder on the table with dramatic force. "I've done months of research." Interesting, very interesting. Research is valuable. Reliable research is even more valuable. I asked a simple question. "Which of these documents specifically discusses your roof?" Silence. Karen flipped through page after page. Nothing. I asked another question. "Which licensed expert inspected your home?" Another pause. "No one." Interesting, very interesting, because once again we return to the same problem. Strong opinions, very little evidence. Then Daniel quietly submitted something unexpected. A county inspection certificate bearing the official seal. Interesting, very interesting. The inspection had been completed the day after construction finished. Relict. Approved. No deficiencies noted. The courtroom remained silent. I looked toward Karen. Did you appeal this inspection? No. Did you request a second inspection? No. Did you hire an independent roofing expert afterward? No. Interesting. Very interesting. Years on the bench teach you that when someone rejects every qualified opinion but offers none of their own, credibility begins to suffer. A lot. Then Karen suddenly leaned forward. I know quality when I see it. Interesting answer. Very interesting, because knowing quality and proving defective workmanship are two very different things. That distinction mattered enormously. The spectators nodded quietly. Even they appeared to understand where this was heading. Then I noticed something else. Daniel hadn't once interrupted Karen. Not once. Interesting. Very interesting. That observation stayed with me because people confident in their evidence rarely feel the need to interrupt. Karen interrupted constantly. Daniel almost never did. Then I reviewed another document from Daniel's file, an email chain. Interesting, very interesting. The dates immediately caught my attention because the emails were exchanged before the payment dispute began. I opened the first one, then another, then another. And honestly, the tone surprised me. Karen repeatedly praised the workmanship. She thanked Daniel's crew. She complimented the appearance of the roof. She even described the finished project as absolutely beautiful. The courtroom became silent, convolute silence. I slowly looked toward Karen. She immediately looked away. That reaction told me everything. Years on the bench teach you that compliments written before litigation often carry considerable weight, especially when later testimony tells a completely different story. I held up the email. Did you write this? A very long pause followed. Finally, yes. Interesting. Very interesting. Because now we had another contradiction, not a small one, a very significant one. And judging by Karen's expression, she already knew what I was about to discover next, because buried deeper inside that same email chain was a message she clearly forgot she had ever sent, a message that would completely change the direction of the case. The moment I reached the next email in the chain, I stopped reading everything else. Not because the other emails weren't important, because this one was very important. Years on the bench teach you that people are often most honest before a dispute begins. Once litigation starts, memories have a strange habit of changing. Jockunks usually don't. The courtroom remained silent. Daniel Brooks sat quietly. Karen Walker stared at the table. The spectators leaned forward. Everyone sensed something important was coming. I read the email once, then twice, then a third time, because every word mattered. A lot. The message had been sent by Karen herself only 2 days after the roof passed inspection. Interesting, very interesting. She wrote, "Thank you for finishing everything before my neighborhood party." The courtroom remained silent. I continued. The house finally looks expensive enough. Interesting. Very interesting. Several spectators exchanged looks, not because of the compliment, because of what came next. Karen continued writing, "My guests won't believe it's the same house." The room became quiet, very quiet. I looked toward Karen. "Did you send this email?" A pause. Then, "Yes, interesting. Very interesting. So at that point, you were satisfied with the work." Karen shifted in her chair. Years on the bench teach you that uncomfortable questions often produce uncomfortable silence. Finally, she answered. At the time, yes. Interesting answer. Very interesting. Because earlier she claimed the workmanship had always been defective. Now her timeline had changed. That distinction mattered enormously. Then I continued reading. Another email appeared. This one had been sent 3 weeks later. Interesting, very interesting. Karen thanked Daniel again, not for repairs, for recommending a gutter color that matched the new roof. The spectators looked increasingly confused because none of these emails sounded like communications from someone furious about defective construction. Not even close. Then I found another message, and honestly, this one immediately caught my attention. Karen wrote, "I'll send the final payment after my insurance reimbursement clears." Interesting, very interesting. The room became silent because suddenly the payment delay had an explanation, not defective work, cash flow. I looked toward Karen. "Did your insurance reimbursement arrive?" She hesitated, then quietly answered, "Yes." Interesting, very interesting. So after receiving the insurance money, you still didn't pay Mr. Brooks. Silence, silence. Karen looked down. That reaction mattered a lot. Then she finally answered, "I changed my mind." Interesting answer. Very interesting, because contracts don't usually depend on changing your mind after receiving the benefits. Years on the bench teach you that satisfaction followed by non-payment often requires careful examination, very careful examination. Then Daniel handed me another document. Interesting, very interesting. A bank confirmation. I reviewed it carefully. The insurance company had deposited funds into Karen's account only 4 days before payment became overdue. The dates matched perfectly. Everything lined up. Interesting, very interesting. The spectators began whispering quietly. The court officer quickly restored order. The Karen sat completely still. Then she suddenly spoke. "They overcharged me." Interesting, very interesting. I immediately looked at the signed contract, then the signed change orders, then the invoices. Every additional charge carried Karen's initials. Every upgrade carried her approval. Everything matched. I looked toward her. Which specific charge was unauthorized? Silence. She flipped through the invoices, but page after page, nothing. Finally, I don't know right now. Interesting, very interesting. Because earlier she seemed absolutely certain. Now certainty was disappearing. Years on the bench teach you that confidence unsupported by facts rarely survives detailed questions. Then I noticed something else. A text message thread attached to the emails. Interesting. Very interesting. The moment Karen saw it, her expression changed immediately. That reaction alone told me it mattered. A lot. I reviewed the first message. Friendly, professional, then another. Then another. Everything remained cordial until one particular exchange caught my attention. Karen wrote, "My insurance already paid me." Interesting. Very interesting. I continued reading. But $42,000 is still a lot to let go. The courtroom became silent. Then came Daniel's reply. "I thought you said you'd send payment this week." Karen answered, "I've been reading online. Maybe I don't actually have to." The room froze. Donald's silence. Nobody moved. Nobody spoke. Even Karen closed her eyes, because there it was, not speculation, not interpretation, her own words. Her own text messages. Years on the bench teach you that sometimes the strongest witness against a person is the version of themselves they forgot existed. The spectators stared. Daniel remained silent. I looked back at the messages. And honestly, the conversation wasn't over, because Karen sent one final text only minutes later, a text so revealing that the entire courtroom would understand exactly why this lawsuit had really been filed. The moment I opened Karen Walker's final text message, I knew the case had entered a very different stage. Not because one message decides every lawsuit, it doesn't. But years on the bench teach you that private conversations often reveal intentions that public testimony never will. The courtroom remained silent. Daniel Brooks sat calmly. Karen stared at the table. The spectators watched every movement, and I began reading the final exchange. Interesting, very interesting. Karen's last message to Daniel was short, very short, but every word mattered. She wrote, "If you really want your money, sue me." The room became silent, absolute silence. I read it again. Then a third time, because I wanted to be absolutely certain. Interesting, very interesting. There was no complaint about defective workmanship, no mention of leaking shingles, no reference to poor construction, just one sentence. "If you really want your money, sue me." I slowly looked toward Karen. "Did you send this message?" A long pause followed, then, "Yes." Interesting, very interesting. Why? Karen shifted in her chair. I was frustrated. Interesting answer, very, very interesting, because frustration explains tone. It does not explain refusing to honor a signed contract after receiving the work you requested. That distinction mattered a lot. Then I reviewed another attachment included in Daniel's records. An audio transcript, interesting, very interesting. Daniel explained that after weeks of unanswered emails, Karen finally agreed to a phone conversation. He legally recorded it with her knowledge and consent under the applicable rules. I reviewed the transcript carefully, then another page, then another. The conversation began politely, very politely. Daniel simply asked when payment would be made. Karen avoided the question repeatedly. Interesting, very interesting. Then came one statement that immediately caught my attention. Karen said, "You'll spend more hiring lawyers than I'll ever owe you." The room became quiet. I continued reading. Daniel calmly replied, "This isn't about lawyers. It's about honoring the agreement." Interesting. Very interesting. Karen laughed, actually laughed. Then she said something I will never forget. "Years on the bench teach you that arrogance often sounds impressive until someone writes it down." Karen said, "Most contractors give up." The courtroom froze. Absolute silence. Nobody moved. Nobody spoke, because suddenly the dispute looked very different. Not a disagreement over workmanship. A strategy, a calculated strategy. Interesting, very interesting. I looked toward Karen. "Were you counting on Mr. Brooks deciding the lawsuit wasn't worth pursuing?" She hesitated. "Years on the bench teach you that hesitation often appears when every possible answer creates another problem." Finally, she answered, "I didn't think he'd actually file." Interesting, very interesting. That answer mattered enormously because it revealed expectation that Daniel would simply walk away. Then I reviewed another document. Interesting, very interesting, a payment reminder. Daniel had offered Karen a payment plan, monthly installments, no interest, no penalties, just an opportunity to resolve the matter without litigation. The room became silent. Karen declined. Interesting, very interesting. Not because she couldn't afford it, because she believed she didn't have to. That distinction mattered a lot. Then something unexpected appeared in the evidence. A neighborhood homeowners association newsletter. Interesting, very interesting. At first glance, it seemed unrelated until I noticed the photographs. Karen's home had won Best Exterior Renovation only 2 weeks after Daniel completed the roof. The spectators exchanged surprised looks. I reviewed the caption. It specifically praised the new roof. Matching gutters and overall craftsmanship. Interesting, very interesting. I looked toward Karen. "Were you present when this award was presented?" "Yes." "Did you object to receiving recognition for the roof?" Silence. "No." Interesting, very interesting, because only weeks later she claimed the same award-winning roof was defective. That contradiction mattered enormously. Then I found another email attached to the Homeowners Association records. The president of the association congratulated Karen on the renovations. Karen replied, "Thank you. The roofing company did an amazing job." The room froze. Dabassel's silence. I read it again, then a third time, because even after years on the bench, moments like that still surprise me. Not because contradictions are uncommon, because this one was so direct. I slowly looked toward Karen. She no longer looked confident, no longer looked irritated. She looked worried, very worried. Years on the bench teach you that eventually every false narrative reaches the point where it cannot survive another document. Karen had reached that point. Then Daniel quietly handed me one final folder. He hadn't mentioned it all morning. Interesting, very interesting. I opened it. Inside was a letter, not from Daniel, not from an attorney, from someone Karen never expected to become involved. The moment I saw the letterhead, I understood why Daniel had waited until now, because the author of that letter was the independent roofing inspector Karen herself had hired after refusing to pay. And according to the first paragraph, his professional opinion completely destroyed the foundation of her entire lawsuit. The moment I saw the inspector's letterhead, I knew the courtroom was about to become very quiet, not because independent experts always settle disputes. They don't. But years on the bench teach you that when someone hires their own expert, they usually expect that expert to support them. When the opposite happens, things become very interesting. The courtroom remained silent. Daniel Brooks sat calmly. Karen Walker stared at the folder. The spectators leaned forward, and I began reading the report. Interesting, very interesting. The inspection had been commissioned by Karen herself, not by Daniel, not by an insurance company, by Karen. That distinction mattered a lot. I reviewed the first page, then another, then another. The report described the roof in remarkable detail: shingle alignment, ventilation, flashing, fasteners, drainage, everything. The inspection was thorough, very thorough. Then I reached the conclusion. I read it once, then twice, then a third time, because I wanted to be absolutely certain. The report stated no evidence of defective workmanship was observed. The courtroom froze. Daval's silence. Nobody moved. Nobody spoke. I slowly looked toward Karen. She immediately looked away. Interesting, very interesting. I continued reading. The installation meets applicable building standards and manufacturer requirements. Again, silence. The spectators exchanged stunned looks. Because the report Karen paid for completely supported Daniel's work. Years on the bench teach you that people sometimes search for evidence expecting validation. Instead, they discover the truth. That appeared to be exactly what happened here. I looked toward Karen. "Did you receive this report?" A long pause followed, then, "Yes, interesting, very interesting." "So you knew your own inspector found no defective workmanship?" Karen swallowed. "Yes." The room became even quieter because now another question became unavoidable. If your own expert concluded the roof was properly installed, why did you continue refusing payment? Karen shifted in her chair, then quietly answered, "I didn't agree with him." Interesting answer. Very interesting. Disagreeing with an expert is your right. Ignoring the only qualified opinion you requested while presenting no competing expert is something else entirely. That distinction mattered a lot. Then I noticed an attachment behind the report. Interesting, very interesting. The inspector had included photographs, high-resolution photographs, every section of the roof, every angle. Every concern Karen had listed. Nothing supported her allegations. Then I found something else, a handwritten note from the inspector. Short, professional, but remarkably important. It read, Homeowner appeared disappointed by findings. The courtroom remained silent. I continued. When informed that no construction defects were observed, homeowner stated she would figure something else out. The room froze. Silence. I looked directly at Karen. Did you make that statement? She closed her eyes. For several seconds, she didn't answer. Years on the bench teach you that some silences carry their own meaning. Finally, yes, interesting, very interesting. Daniel never smiled, never celebrated. He simply sat quietly. That observation stayed with me. People who know the facts are on their side rarely need theatrics. Then Karen suddenly leaned forward for the first time in nearly an hour. But I still shouldn't have to pay that much. Interesting. Very interesting. Notice what had changed. She no longer claimed the roof was defective. She no longer challenged the workmanship. She no longer questioned the inspection. Now the argument had become the price. Years on the bench teach you that when someone's position changes repeatedly, credibility begins to erode quickly. I picked up the signed contract, then the signed change orders, then Karen's emails praising the finished roof, then her own inspector's report. Every document pointed in the same direction. The work had been completed. The work had passed inspection. The work had been praised by Karen herself. The work had been confirmed by the independent expert she hired. Interesting, very interesting. Then I reached the final page of the inspector's report, and honestly, this was the moment the case truly ended, because attached to the report was an invoice, not for repairs. For the inspection itself, Karen had never paid the inspector either. The courtroom erupted into whispers. The court officer immediately called for order. Agon. And again. Because suddenly a pattern emerged. Daniel wasn't the only professional claiming he had completed work without being paid. The independent inspector was making the same complaint. I slowly looked toward Karen. She realized exactly what everyone else in that courtroom had just realized. This was no longer beginning to look like a dispute over a roof. It was beginning to look like a pattern of refusing to pay after services had already been performed, and that realization was about to change everything. The moment I realized the roofing inspector had also gone unpaid, the final pieces of the puzzle fell into place, not because failing to pay two people automatically proves wrongdoing. It doesn't. But years on the bench teach you to pay attention to patterns. Parse often reveal what isolated events cannot. The courtroom remained silent. Daniel Brooks sat calmly. Karen Walker stared at the table. The spectators watched without saying a word, and I reviewed the evidence one final time: the signed roofing contract, the approved change orders, the county inspection. Karen's emails praising the completed work, her Homeowners Association award, her own independent roofing inspection confirming the workmanship met professional standards, her text messages, her recorded phone call, and now the unpaid inspection invoice. Everything pointed in one direction, not toward defective construction, toward a deliberate refusal to pay. Interesting. Very interesting. I looked directly at Karen M. Walker. Is there any qualified expert who has concluded Mr. Brooks performed defective work? A long silence followed. Then, no. Interesting. Very interesting. Is there any document before this court showing the roof's failed inspection? No. Any engineering report? No. Any manufacturer warranty denial because of improper installation? No. The courtroom remained perfectly still. Years on the bench teach you that sometimes the most powerful evidence is what doesn't exist. Karen had made serious accusations. Yet after hours of testimony, not a single qualified expert supported them. That mattered a great deal. Then I addressed Daniel. Mr. Brooks, after completing this project, did you make reasonable efforts to resolve this matter before filing suit? Yes, Your Honor. He handed me copies of every email, every payment reminder, every settlement offer, every installment proposal. He even offered to reduce late fees if Karen simply honored the contract. Interesting, very interesting. Karen rejected every one of them, not because the work was defective, because she believed he would eventually walk away. She said so herself. Years on the bench teach you that good faith efforts matter. Daniel made them repeatedly. Karen did not. I leaned back for a moment and looked around the courtroom at the spectators, at the evidence, at the people who had spent the morning watching facts quietly dismantle assumptions. Then I turned back toward Karen. Earlier today, you stood in this courtroom and pointed at me. She slowly nodded. You told me you paid my salary. Another pause. Yes, I looked directly at her. And today you've learned something important. The people who fund this courtroom don't pay me to believe the loudest person. They pay me to follow the evidence. The room became completely silent. Not because my words were dramatic, because they were true. Karen lowered her head. For the first time that day, she looked genuinely humbled. I entered judgment in favor of Daniel Brooks. The unpaid contract balance was awarded, along with allowable court costs and applicable interest under the law. The evidence overwhelmingly supported his claim. Karen's allegations of defective workmanship were unsupported. Her own documents contradicted her testimony. Her own expert contradicted her testimony. And her own communications revealed that she expected Daniel to abandon his claim rather than pursue justice. Silled, direct scored by facts, Daniel quietly thanked the court. He didn't celebrate. He didn't smirk. He simply gathered his papers. That told me everything I needed to know about his character. Then I looked toward Karen one final time. Years on the bench teach you something I wish more people understood. Confidence is not the same as credibility. Volume is not the same as truth. And reading articles on the internet is not the same as understanding the law. You are absolutely free to disagree with a contractor. You're free to ask questions. You're free to hire independent experts. But once every qualified opinion confirms the work was properly completed, the law expects contracts to be honored, not avoided. As people slowly began leaving the courtroom, I found myself thinking about Karen's first words to me. I pay your salary. Interesting, very interesting, because in the end, she wasn't entirely wrong, like every taxpayer. She contributes to the public institutions that serve our communities. But she misunderstood something fundamental. Helping fund a courtroom doesn't purchase control over its decisions. It doesn't buy favorable rulings. It doesn't place anyone above the law. If anything, it creates a greater responsibility to respect the system that serves everyone equally. Years later, I still remember that case, not because of the money, not because of the roof, but because of the lesson. Karen believed authority could be intimidated. She believed confidence could replace evidence. She believed shouting could outweigh signed contracts, inspection reports, expert opinions, and her own written words. Instead, every document quietly told the same story. And by the time I announced my decision, the loudest voice in the courtroom had become the quietest. Because in every courtroom I've ever served, respect may be earned, arguments may be persuasive, but only evidence decides the case. And once the evidence speaks, everyone else eventually stops talking.